SJC-13819, J.C. Cannistraro, LLC versus Columbia Construction Company.
Okay. Attorney Bernarducci, whenever you're ready. Bernarducci, sorry, Justice Graziano corrected me, Bernarducci.
Good morning, and may it please the court. My name is Jeff Bernarducci, and I'm representing the appellant Columbia Construction in this matter. Your Honors, the issue on appeal this morning is whether the arbitrator exceeded his powers by allowing Columbia's counterclaim to proceed in violation of the Prompt Payment Act, General Laws, Chapter 149, Section 29E, subsequently interpreted by this court after the award in the Business Interiors versus Gray Corps construction case, and then is retroactively applied by the Superior Court as the basis for vacating the award. The issue on appeal requires a determination of 4 key items in our view, including number 1, whether the arbitrator violated an express statutory requirement or well-settled public policy. 2, whether Gray Corps applies to the facts of this case, even if retroactivity is appropriate. 3, whether Gray Corps' implied waiver rule extends to counterclaims and bargain for defenses. And 4, whether Columbia's payment of deemed to be approved invoices per the arbitrator's order and after asserting its defenses complies with the act and with Gray Corps. Your Honors, we're asking that the court reinstate the award and protect the sanctity of arbitration. The Superior Court vacated the arbitration award on grounds that the arbitrator exceeded his powers. As this court well knows, in order to for an arbitrator to exceed their powers, it requires 1, a violation of an express statutory provision, and 2, a violation of well-defined public policy. The Superior Court didn't find a violation of an express statutory provision. The Superior Court overturned the arbitration award based on the Gray Corps, the holding in the Gray Corps decision, the necessary implication analysis, the implied waiver rule that was decided after the arbitration award was decided. The Superior Court applied this court's statutory interpretation retroactively to reverse the award. It didn't find it a violation of an express statutory provision.
But when we interpret a statute, we're saying what the statute says.
That's correct, Your Honor.
So I don't understand your argument that this isn't a violation of the statute, of the express statute.
Yeah, Your Honor, respectfully, it's not that it's a violation of the express statute. The case law from this court is that there needs to be the arbitrator needs to violate an express provision of the statute. If
in Gray Corps we said the statute requires X, and the arbitrator awarded, I don't know what you call it, damages to Columbia in violation of X, how is it that the arbitrator didn't violate the statute?
What you have there, Your Honor, is you have an error of law, which is not proper grounds for vacatur. And so it could very well be, in fact, that an arbitrator could make a decision. An arbitration is, again, it's a bargain for situations of parties.
What is the difference between what you're saying is an error of law and the express statute violation, if the error of law is our construction of the statute?
So, well, for example, in this case, Your Honor, probably the best example is that there's nowhere in the statute, in the Prompt Payment Act, is there express provision that says that that there is a waiver if a party doesn't make payment after there's been a violation.
The language is that the claim is deemed approved. That's the language. The statute says that it shall be deemed approved.
That is correct, Your Honor.
So, I mean, and we gave meaning to that phrase in Gray Corps. So why is that not an express? I mean, why is that not an express part of the statute?
It's not an express part of the statute, Your Honor, because that is this court's interpretation of what the statute means and how it should be applied.
When we interpret a statute, we don't add words to the statute. So we said in Gray Corps, deemed approved means you got to pay it before you assert your defense.
I don't know that that's what that. Respectfully, Your Honor, I don't know that the court defined deemed approved necessarily in the case. I think that the court applied the necessary implication analysis in order to give meaningful consequences to the statute. Set forth a rule by which if a party doesn't pay contemporaneously with or before it asserts its defenses, then it loses all of its defenses, whether they're related to prompt payment or otherwise. So that's part of the whole one of the issues here. And let me step back for a moment. This court doesn't necessarily need to do anything with Gray Corps in order to reinstate the arbitration award. The most important thing in front of the court here, in our view, is to make sure that we are protecting the sanctity of arbitration and the high standard that is applied in order to overturn an arbitration.
Can you explore the difference between the common law defenses in Gray Corps, which was impossibility, the holding in Gray Corps, and what's at issue here, that being counterclaims?
I'm sorry, Your Honor, to explore the differences?
Yeah, we didn't hold, Gray Corps did not, it may follow from Gray Corps, but it didn't hold that counterclaims need to be asserted, correct?
That's correct. Our read of the Gray Corps case is that the court stopped short of applying the waiver to bargain for defenses and to counterclaims. And that makes sense. I think that my take is that the court stopped short of applying the waiver to bargain for defenses, contract defenses, because then the court would be reaching in to private contracting. There are a number of well-settled provisions in construction contracts that have that are negotiated, have nothing to do with prompt payment. And if the waiver applied to contract defenses, then that would be undoing all of the defenses that parties have specifically negotiated for. So that's why I think the court was very clear. It talked about common law defenses everywhere in the case. There's only one spot in the Gray Corps construction case where it says any defenses, and the Cannistraro group tries to point to that one spot. But if you look at the case, it's clearly the analysis is about common law defenses, because that's all that was before the court at that time. It was about the impossibility defense.
So as a matter of principle, though, given the reasoning of the opinion in Gray Corps, how are they different, right? The whole point in Gray Corps of the court's decision was that we can't give effect to what the legislature has asked for here if defendants can just litigate all their defenses, notwithstanding the fact that they have not promptly paid the deemed approved amount. So why should there be a different result with respect to counterclaims or bargained for defenses as opposed to common law defenses?
So there should be a different result with respect to contract defenses and counterclaims. Number one, as I just indicated, Your Honor, because contract defenses, they're bargain for defense. It's private contracting. And because there is no waiver set forth in the statute, that's not something that the court necessarily needs to do in order to provide meaningful consequences to the statute.
Isn't the context that this case arises more important in that it may well be that counterclaims are included within the ambit of Gray Corps, but what we're looking at really is what was before the arbitrator and whether the arbitrator, given the deference, violated an express provision of law at the time.
That's correct, Your Honor, and an excellent point. It's important to remember what was before the arbitrator at the time. What was before the arbitrator, this case came up in the pre-Tachi era, the pre-Gray Corps era. So at the time, when Columbia had a good faith dispute, which distinguishes this case from Gray Corps, Columbia had a good faith dispute as to whether it, in fact, violated the statute, and therefore, in fact, whether there were any deemed to be approved invoices at all. And so that was before the arbitrator. So this case, the facts of this case, actually, I'm making my way around to Your Honor's question, but this case, from a factual standpoint, it happens even before the Gray Corps analysis starts, because the Gray Corps analysis presumes deemed to be approved invoices. That wasn't an issue in this case. Here, a factual and legal issue in this case right from the beginning was whether there was a statutory violation and whether there were any deemed to be approved invoices at all, because again, we're in the pre-Tachi era. No one knew how strictly or not strictly construed the statute was going to be. So what did the arbitrator have in front of him? At first, the arbitrator had the decision as to whether there were any deemed to be approved invoices at all. And once he made that decision, that's when Columbia made the payment. Granted, it was per the arbitrator's order, but that's the moment when you have the deemed to be approved invoices. Columbia made the payment, and the arbitrator, allowed the counterclaim for recoupment to proceed thereafter. As part of that order, that required Columbia to pay, found that there were deemed approved invoices. There was never the arbitrator didn't rule on any of the other defenses that were brought up on the motion at that time. All the arbitrator ordered, the only rule that came out of that interim order was the fact that there were deemed approved invoices and had to be paid by Columbia. So I just want to put a bookend, Your Honors, on the fact that the Gray Corps case, this case is very different from the Gray Corps case. It's a critical distinction. The fact that parties should be able to litigate whether there is a violation of the statute at all. Otherwise, instead of a statute about having deemed to be approved invoices, it's a statute about you're deemed to be in violation of the statute. Parties should have the right to litigate that, and that's what happened. That's what happened in this case. So the critical issue here, Your Honors, and while you don't have to, you really don't have to touch Gray Corps one way or the other in order to find that the arbitration award should be reinstated. Because the Superior Court relied on the Gray Corps case, we're asking that you take another look at it as part of your decision, because the issue that arises from the implied waiver rule that comes out of the Gray Corps case, or the risk of it, while a well-reasoned decision, there is an unfair, there's the specter of unfair windfalls, which this case represents. Ultimately, this case was litigated on the merits, and it was determined that Cannistraro could not prove almost 60 or support 60% of its claim. And so therefore, if the arbitration award was not reinstated, Cannistraro would hold on to $576, in round numbers, $1,000 that it couldn't prove at trial. That's an unfair windfall. It's a statutory penalty, which is basically what's happened here, without an express provision in the statute setting forth a penalty. And
it seems like a little bit of a backdoor way of arriving at a statutory interpretation. If on the facts, Columbia had failed to prove that any of the invoices were overcharges, so that it owed the full amount, you would still be arguing for the same interpretation of the statute, though, which is that, or the outcome here, which is that the recoupment counterclaim could be asserted after payment was made. So I don't really understand why the fact that, how much of the invoices were overcharges would play into the interpretation of the statute itself, or the interpretation of the application of Gray Corps to this case.
it doesn't, Your Honor. And so I would agree with you there. But what we're trying to highlight for the court is what is
What is the potential implication of a contrary rule?
Yes, what is the potential implication? How is the Gray Corps holding? How is it now living and breathing in the industry? This court didn't have the benefit of a test case or certain facts and certain experience with the holding that it ended up putting forth in Gray Corps. But now it does. 2 years have gone by. And so this is a perfect case, and there'll be others like it. So whether
Can I ask you if this is just the issue raised in this case is just an issue of a vanishing problem, because this is a sophisticated industry with sophisticated counsel and experienced arbitrators. Presumably 2 years out from Gray Corps, everyone now knows the ground rules, and this is taking care of itself. Is that your impression?
it is not our impression, Your Honor. That's one of the reasons why we asked for this court to hear this specific case, because we don't want Gray Corps to be construed by the Superior Court or other lower courts as the new as a per se retroactivity rule, or to be able to undo arbitration provisions. Again, the most important thing before the court here is to protect the sanctity of arbitration, and the Superior Court underneath here didn't find a violation of an express provision, but it applied the holding, whatever it is, say for a moment, but it applied that holding retroactively. And so it's not a vanishing issue, because what will happen is that anyone that gets an award adverse to them in the construction industry, which heavily relies on alternative dispute resolution, heavily relies on arbitration, provides certainty in a very risky industry, it will open the floodgates to parties coming in and challenging these arbitration awards based on what happened here in the Gray.
So is it the retroactivity piece that's the problem, or is it the view about arbitrability, or is it the counterclaim piece that's the future problem? That's the ongoing problem, sorry.
I think it's the retroactivity is one of the major problems, Your Honor. I mean, the counterclaim piece is an issue as well, because the court within the statute, there's enforcement mechanisms. It doesn't need a necessarily implication analysis. While it's well reasoned and certainly it works, it provides meaningful consequences, but there's no proportionality to the result. Here we have rights that are waived, and so the statute itself has its own enforcement mechanisms. There's the continuing work obligation that occurs in many construction contracts. That is now void and unenforceable. So a party, if it's aggrieved by what it feels to be a prompt payment, it can properly stop the work. It can protect itself. It can go in and seek an injunction. It doesn't even have to wait till a lawsuit happens 2, 3, 4 years down the road in order to make the argument that payment wasn't made prior to or contemporaneously with asserting defenses. So they can, in real time, bring leverage, stop the work, and try and avail themselves of their prompt payment rights.
Okay, thank you very much.
Thank you.
Attorney Cole.
Your Honors, may it please the court. Nathan Cole for the appellee, J.C. Cannistraro. This case presents a perfect example of why the legislature enacted the Prompt Pay Act. And to get to the question about whether this is a vanishing problem, where I agree with my brother, it is not a vanishing problem. What we have here is an example of a party that violated the Prompt Pay Act. There's no question. What we're seeing in the marketplace is parties that violate the Prompt Pay Act are continuing to exacerbate the very problem that the legislature saw fit when it enacted the Prompt Pay Act. That is to, one, have the cash flow, but more importantly, to not take advantage of downstream subcontractors, which is precisely what happened here. Whether it was deliberate and strategic or not, what we're seeing and what a real concern is here in the industry is that contractors or owners that are violating the act, if there is not a meaningful consequence, they will hold on to that money for as long as possible. And why wouldn't they? Because in this case, in this instance, they were able to do that and then have an arbitrator come in and exceed his powers by crafting a remedy that is nowhere found.
Was he exceeding his powers at the time that he made the award?
He was, Your Honor. And he was, whether Gray Corps is applied retroactively or not, he exceeded his powers for two main reasons. One, he crafted an extra statutory remedy that goes directly against express language of the Prompt Pay Act, specifically the express language that speaks to deemed approved, and that language must have meaningful consequences. But moreover, he also went against the express language that contemplates a specific type of payment in order to preserve defenses. That specific type of payment is a periodic progress payment. What he allowed to have happen was a party that failed to properly comply with the Prompt Pay Act's requirements with regards to the rejection. Did that both at the level of the change orders, that was one strike in which there was no proper rejection, not a ministerial, but a significant, meaningful failure to certify the rejection in good faith. Then again, at the level of the payment requisitions, not a proper rejection. Then, when there's a 45-day clawback period that the legislature saw fit to give yet another opportunity for a violating party to be able to preserve defenses or counterclaims, they failed to do that. And then, when they answered the complaint, first in Superior Court and then in the arbitration, They had a moment to decide, while represented by counsel, whether to make that payment in the form of a periodic progress payment as expressly required by the statute, or to hold on to the money and to challenge the party that did nothing but submit requisitions and wait to find out why they were
Sorry,
not.
can I interrupt you there? So there was a dispute here about whether they had violated the Prompt Pay Act, because they did give a whole bunch of reasons why they were rejecting the payment. And they took the position that that was good enough. And then later on, they provided the good faith certification. And it seems to me that just because someone raises the specter of a Prompt Pay Act violation doesn't mean that they have to just give up that moment. They can litigate the question of whether there was or was not a Prompt Pay Act violation. So why was what the arbitrator did here not exactly the right thing? The arbitrator first said, okay, we have to figure out whether there really was a Prompt Payment Act violation. I'm going to focus on that question, decides there was, makes them pay, and then deals with, and only after they've paid, because it was deemed approved, only after that litigate any and all defenses to the payment. Why isn't that the correct order of operations? And what would you propose is the right order of operations, where, as here, there's a real dispute about whether there's a Prompt Payment Act violation at the beginning?
Well, one, that's a far cry from prompt payment or prompt response with a certification as to why that payment isn't being made. So right there, the handling and the order of operations that the arbitrator allowed and is now incentivized.
Well, we said in the Gray Court itself that the fact of a Prompt Payment Act violation does not in and of itself mean that the defendant can never get the money.
That's right. And then that's absolutely true. And that's also a position that's been consistently advanced by the associated subcontractors, both at the level of Tachi, with Gray Court, and in this instant case.
So what should happen? So let's imagine, let's just get away from this case. There's a future case. Someone, let's just change the facts. They give reasons for the payment, for rejecting the payment, but there's a question about whether they gave good enough reasons. What should happen next?
Sure, Your Honor. What an upstream party should do and must do under the Act is timely and properly reject. So in writing, stating the factual and contractual bases.
That's clearly their obligation, but I'm asking, what do we do if there's a question about whether they have met that obligation?
If they have not properly rejected, then by the time it gets to the point where they have to make a determination as to whether they pursue affirmative defenses and potentially hold on to the right to claw that money back or to bring an unjust enrichment claim or a recoupment claim, however they want to frame it, they have to make a decision in that moment, because they know at that point that they violated the Prompt Pay Act by not strictly complying with the requirements, and that those are not municipal.
Well, they don't know, right, until a court or arbitrator decides, right?
I don't think that the arbitrator finding the violation of the Prompt Pay Act is when the violation took place. The arbitrator was memorializing something that had taken place years before, and they made that decision. The order of operation should be in that moment where they have to make a decision about whether to proceed with the litigation. That's the moment of truth, and that's the moment where there must be meaningful consequences for the violation. They're rolling the dice by answering the complaint, pursuing affirmative defenses, and what they want is to have their cake and to eat it too. And that is expressly against the...
So you're defining at the moment as the filing of any kind of anything in defense of a claim brought by a sub?
No, although in this instance, Your Honor, with this particular case that's before the court, there's no question that Columbia advanced and pursued its affirmative defenses. In fact, it went so far as to use those defenses to cross-move for summary judgment. Now, it was found that those were not effectual at the time. There's no question that it did that in this instance. I think what Your Honor is asking is sort of more broadly what the roadmap looks like. And I would say it's as simple as what's in the Act and as simple as what was found in Tachi and by this court and Gray Court. It's very easy, first of all, to properly reject the change order or the requisition. If you miss, then the legislature has saw fit to give the additional 45-day clawback period. If you still miss, then by the time it gets to that point where you have to make a decision about forcing the other side to actually prove its case, and you are aware of defenses, in that moment where the party answers and decides it's going to pursue its affirmative defenses, that's the moment where the payment has to be made. I could see a world, although again, not present here, in which a party in good faith, having violated the Prompt Pay Act, nevertheless is not certain of whether it has affirmative defenses to pursue. there's a world in which, and I think consistent with the holding in Gray Corps, that party answers the complaint but does not raise affirmative defenses. Rather, it goes through discovery, which is what took place here after it raised affirmative defenses. But in this hypothetical, the party could pursue through discovery whether it has a factual basis. It could look at the backup for the claim. It could look at the methodology that's used in the claim. When it gets to the point where it realizes that it in fact has valid defenses to the deemed approved amounts, and it has violated the act, it then, under the rules of civil procedure, should move for leave to amend. And that leave should be freely given. But at that moment, if they're going to go down the road of advancing those affirmative defenses, that's the time to pay so that those affirmative defenses and recoupment claims are preserved. That's completely
So you see the point of the moment of asserting a defense as opposed to litigating a defense as the critical moment?
I do, and I think for two reasons. One, I think when you're availing yourselves of the protections under the common law and you would like to preserve those where you've violated the act, that's the moment. Two,
How do you reconcile that with the rules of pleading, which require that affirmative defenses be asserted at the earliest, like in the initial responsive pleading?
I think that is an issue that we are seeing, that is parties strategically, deliberately looking at the Gray Corps holding, and I think saying to themselves, if I don't answer with an affirmative defense, then I can leave my options open. That's a problem.
Right. I think that might be an overreading of Gray Corps, perhaps. What do you think?
I think that while Gray Corps has expressed that you have to pay prior to or advancing the affirmative defenses, I think there is a logical consequence of that, which is, or when you should have raised those affirmative defenses. Because I think at that moment, if you have a legitimate reason to raise affirmative defenses, then in order to give meaning and have meaningful consequences to the act, and this court's analysis of the necessary implications of the act, that's the moment where that payment
That
has to be made.
seems to bring Gray Corps into direct conflict in my mind with the ordinary rules of civil procedure. I'm not sure why the answer wouldn't be instead that what Gray Corps means is that you have to pay before you can get an adjudication of those defenses. That seems to me to, an interpretation that would avoid the problem you're talking about. Or am I missing something here?
No, I think a bright line rule like that, Your Honor, is appropriate. That didn't happen in this case, but I agree with you. I'm flagging for the court that I do think what we're starting to see in the industry is people that are trying to find the loophole of Gray Corps, and that should not be allowed and sanctioned. It was exactly what happened in the arbitration, and that's part of the reason why the arbitrator exceeded his powers, both in terms of disregarding the obligation express in the statute to make a periodic progress payment, not a payment under compulsion after you've taken your chance and rolled the dice and forced the other side to now finance not only the project, but to finance the litigation to chase after that money. And that's what happened here. That is going against the express requirement of a periodic progress payment and deemed approved. It essentially renders that language meaningless. Moreover, under the holding of Gray Corps, to the extent that it is applied retroactively, we submit it should be, they clearly didn't comply with the pay-to-play rule of Gray Corps, and a rule that is reflected not only in Gray Corps, but notably in Tachi as well. One of the statements made earlier was that the arbitrator at the time that he issued his decision didn't have the benefit of Gray Corps. He did have the benefit, however, of Tachi. And if the
Here, he seemed to have miraculously gotten pretty close because he didn't permit adjudication of the counterclaim or even assertion of the counterclaim until after payment had been made. And so it seems to me that the case really does boil down to what Justice Gaziano asked about earlier, which is there a difference between asserting a common law defense and a counterclaim when it comes to Gray Corps? In other words, does Gray Corps apply the same way to counterclaims?
There's no difference. And there's no difference here because for the very reasons that the legislature enacted the Prompt Pay Act to force a party to pay or to explain why. And the very logic that this court applied in Gray Corps with regards to the necessary implication, it is not saying, and no one, at least on behalf of the appellee or the associated subcontractors, have said that the violation of the act equals a waiver of anything. It's the violation of the act compounded with this potential strategic decision to hold on to the money. That's where they walk into the waiver. And that's a result of the decisions that they made. That applies here to the recoupment claim because, as we've briefed, the recoupment claim, by Columbia's own admission, is identical to the very same defenses that they raised. They argued to the arbitrator that there's no prejudice, and so allow us to take our defenses and simply recast
Except
them.
that they didn't assert it before they paid. That's the difference.
They certainly pursued those very same affirmative defenses.
But they didn't assert a recoupment counterclaim.
No, they did not assert any counterclaims.
Right. So it feels to me we get into this kind of loop about that's caused by understanding Gray Corps to mean the moment of assertion as opposed to litigating that the merits of a claim, either whether it's a common law defense, a recoupment counterclaim, or some kind of other defense to payment.
I understand your question, Your Honor, but I would say Gray Corps is very clear, and the industry understands Gray Corps is very clear, and that's why you see so much energy being put into this case by all parties, but particularly the upstream subs, because they recognize that under Gray Corps, clarifying the act and furtherance of TACI, the periodic progress payments have to be made before you pursue those defenses. It's a very bright line. So whether it's in the form of an answer or in the form of pursuing affirmative defenses, what you cannot do is what the arbitrator allowed and, in fact, incentivized here,
Well,
which is...
Can I just press you on that? Because you've said it a couple of times now. I just want to get your answer to it. So assuming that you think that Gray Corps was this clear in announcing this implied rule, why is it that what the arbitrator did here, why does deviation from it constitute an excess of the arbitrator's power rather than just legal error? Because that would be important, because that's our standard of review.
That is an important distinction. We recognize this gravity of the arbitrator's role in the justice system, and we don't question that. What we're saying is that the arbitrator exceeded his powers. When you look at the TACI decision, Your Honor, TACI on rescript addressed the very same issue that Gray Corps merely affirmed. Specifically, there was a request for clarification in which they went to this issue of how do you preserve your defenses and potential affirmative counterclaims, and when in the context of the type of payment does that take place? And the rescript for the decision states it changes this language, including a party that under the statute makes a periodic payment in response to an application. The TACI court was well aware of this potential issue of what type of payment and when must payment be made in order to preserve those defenses. The arbitrator had TACI. That's completely consistent with the Prompt Pay Act and the express requirement of the periodic payment. But Gray Corps is almost irrelevant to the instant question of whether the arbitrator exceeded his powers by crafting this extra statutory remedy found nowhere in the statute, and by failing to have the language regarding deemed approved and the language requiring a periodic progress payment, not a payment after you've tested your defenses and dragged a party through litigation and then been ordered to pay. That does not revive defenses that this party, Columbia, waived by virtue of gambling when it answers its affirmative defense. So this is an opportunity, to the extent there needs to be any clarification, I think it can simply be, if you're going to violate the act and if you want to preserve your defenses or the rights to bring counterclaims, whether it's recoupment or anything else related to those deemed approved amounts, you have to make the decision to pay, and what you cannot do is hold on to the money and continue to exacerbate the very inequities and problems with leverage that the Prompt Pay Act was designed to eliminate.
Thank you.
Thank you, Your Honors.